Yeah, so there's really a timeline of each one of these cases. They all go through the same process, and what initially starts it is this initial phase when a mass tort's consider emerging. So there could be a number of factors that start off the interest. We could get contacted by a number of people that were hurt by a similar product. There could be a study that comes out that links a certain product to these particular injuries. There could be an FDA recall. There could be an FDA warning label change. There's something that we call a triggering event that really starts our interest in examining these potential cases. And during that initial phase, we're really gathering information, gathering the evidence, trying to learn more about the science, tee up our experts to make sure we're going to be able to win these cases. So usually I only see the most experienced mass tort law firms get involved up front because the risk is huge. The injuries aren't nailed down. The science might not be 100% set. The criteria is in flux and it's going to change as the case goes forward. So I always get those emails. I'm sure everybody else here does about, get involved now. Here's this new mass tort. I don't think that's always the best opportunity for everybody to get involved. Um, and then as we move forward in this life cycle of the case, after we have the MDL formed, so that emerging tort usually takes maybe 6 to 9 months before we even really get the cases going. And then once we're in this litigation phase, the risk, the uncertainty is a little bit less. But as the litigation phase goes forward and we're involved in discovery, we're learning and strengthening our theories in the case. We're learning about these really hot documents. We're identifying the key players. We're really able to put that picture together like you do in your traditional motor vehicle case or slip and fall. We're gathering that evidence. And as time goes on and goes on, the criteria is going to tighten. We're going to really know what these cases are about. And then as we go through this litigation phase, which usually takes a year to 2 years, the case is getting stronger and stronger. And that's a better opportunity to get involved, I would say, than that emerging phase. And then after we get to the litigation phase, we're always going to go to that Dahlberg hearing. So this is where the whole litigation is going to hang in the balance. We have to have the experts come in to be able to testify because without that, we're pretty much dead in the water. So every one of these cases, we're going to have to go and we're going to present usually multiple experts on a specific issue, offering differing opinions to make sure we're protected. And all of these cases will end up having Dahlberg hearings in front of the judge. Typically, they're multiple days. Some cases, they even go on for weeks. That's how important these issues are and how dense the science is. But once we get past the Dahlberg hearing and we end up winning and our experts go through, that's really where the risk is minimal. They still have to prove the specific causation. Each case is going to be different, but generally we know this theory's sound. The court pretty much approved it, and we're going to be able to present the picture to the jury. And at that phase is usually when we start getting into this settlement discussions, right? We're trying to figure out how many cases are there? What's the real value of these cases? What are the real injuries? Are there multiple injuries that are going to be compensated? And of course, during that settlement phase, everybody's excited about it. The risk really is minimal, but is there still opportunity to acquire new cases to help new people? It's going to be a lot lower than somewhere earlier in this timeline.